Hey YouTube family and GN subs, how are you? Hope you're doing well. We got two great new changes in immigration law that I'm going to unpack today that we're going to talk about. These are huge decisions. I'm so happy it's going to help me in my practice with my clients on several different types of cases. So we're going to get to it. For those of you who are new to the channel, my name is Humberto R, attorney at law. I am here on the West Side, Los Angeles, and I've been practicing for quite some time. I know this stuff, immigration law, and what I do is I give you good news. I bring good news, baby. That's what I do. I do break down complicated subject matter. I make it very simple to understand. I have an unbelievable playlist. Go to my playlist and you can learn a lot about immigration law. I have it outlined, digested perfectly, so you can get through it and really learn some stuff. So hey, two new changes today. Let's go through them and get at it. A lot to unpack. The first is the 3 and 10 year bar. You've been hearing about this stuff, right? So there is a new decision that came down. We talked about this in previous videos, but the issue is whether or not, if you have a 3 or a 10 year bar, where do you need to wait? Do you need to wait inside the US or outside of the US? Okay, that was the issue. And now there's two sections to this 212A9, it's called. There is a bar under the B section and a bar under the C section. We're not going to discuss the C section today because that's the permanent bar, okay? What we're discussing today, and I'm going to give you a wonderful example to make it very simple for you. This is the bar under section B, all right? It could be 3 or 10 years. So generally, if you have overstayed your visa or you entered illegally, if you are unlawful in the US for 6 months or more, you can be subject to a 3-year bar. If it's more than 6 months, less than a year. If you're unlawful for more than a year, it's a 10-year bar. So where do you need to spend this time? Here in the US or back in your home country? A USCIS interpretation was that you had to wait outside of the US for this time period. Wonderful case came down and said, no, that's not correct. You can wait in the US as well. All right, so let me give you an example because again, this stuff can get a little bit complicated, but I'm going to make it very simple. This is how it works, all right? So let's say an individual in 2010 gets a multiple entry visitor visa. Individual comes into the US 2010, stays here for 2 years, then departs the US. So the initial entry was only valid for 6 months. That's usually the time frame that they give you on a visitor visa. You could stay here 6 months, but you have the visa in your passport for multiple entries, okay? So that's 5 years. All right, so overstayed for more than a year, definitely subject to the 10-year bar. The 10-year bar comes into effect when that person departs the US. You have to depart as well. So this individual stays for 2 years, departs. Visa is still valid. Individual comes back to the US, let's say in 2014, on that same visitor visa and is allowed into the US. Usually they're stopped at the airport because the overstay will be notated like in the system. But in the old days, it really didn't happen. They didn't have the computer capacity, certainly back in 2010. So let's say the individual comes back, overstays again, and is in the US today. So here we are in 2022, years later, 10 years later, waited in the US, and now the person gets married and they want to adjust their status in the US. They can file for an adjustment of status and indicate to the officer, look, I've waited my 10-year period, although it was here in the US, cite the case, that person is golden, can adjust and can get the green card here in the US. So that's a wonderful case. That's going to be helping a lot of people in the US, certainly my clients. Second big development, rescission of matter of ZRZC. This is a case regarding TPS and those who traveled with advanced parole on that TPS and re-entered the US lawfully. This decision was an administrative decision that said, no, if you leave on TPS on advanced parole and you come back, you still revert to the status you were prior to issuance of the TPS. So in a lot of times, individuals were in unlawful status, so that it was kind of weird, right? I mean, You entered legally under this advanced parole TPS, but you're still illegal. It made absolutely no sense. Well, immigration just recently rescinded a matter of ZRZC, which is great news. So now, if you travel on TPS, and certainly today, a lot of TPS is being granted now. You got Haitians, you got Cuba, you have, of course, Ukrainians, Afghans, Central America. Lots of status under TPS is being issued today. So this is really fascinating that if you are unlawful, you're issued TPS, you get advanced parole, you travel and you make a reentry, guess what? That's a lawful admission and inspection, and you can adjust your status in the U.S. Let's say you marry a U.S. citizen, you made that lawful entry, you can adjust your status. So let's break it down. Let's say you entered the U.S. illegally, entry without inspection. We call it EWI, right? And subsequent, let's say years go by and your country is designated for TPS. You can get TPS, you can have it issued, you can travel on advanced parole, make an entry. Guess what? That's a lawful entry. You can adjust your status in the U.S. So for a lot of people, this is going to be really helpful in terms of adjusting status in the U.S., lawful status. Hey, that's great news. Thanks so much for watching GrayLaw TV. Click below, like and subscribe. We'll see you next week.